for 1501.
For sensitivity towards offense against women, children, and other marginalized groups passes through various phases of evolution. Whereas the end goal is most desirable, the journey is not always a pleasant one. At times, the victims find themselves pushed against a system full of insensitive stakeholders, and at other times, the victims find themselves in conflict with the procedural intricacies of laws in place. Despite the importance of procedural sanctity, it is always a matter of utter failure for the system as a whole when a culprit, that too of a heinous sexual offense, manages to walk free by entangling the victim in misapplication of procedural rules without the knowledge of the victim and without any control of the victim. The present case presents one such illustration from a place called Pairo district, Bhojpur, Bihar. In this case, the accused were convicted by the trial court. However, they were acquitted by the high court. And we have affirmed the trial court judgment. In the present case, a fairly consistent and creditworthy case of the prosecution has been discarded on what could only be termed as misapplication of procedure. It takes us back to the first principle that procedure is not supposed to control justice. In view of the foregoing discussion, we are of the considered view that the impugned judgment is liable to be set aside being unsustainable. The view taken by the trial court was correct, and we find no infirmity in the same. The judgment of the trial court stands restored both on conviction and sentence. The respondent 1 and 2 shall surrender before the trial court within a period of 2 weeks from today. In case the respondent 1 and 2 do not surrender within the stipulated time, the trial court shall take appropriate recourse to take them into custody for serving the remaining part of sentence. Rest is directed to suitably communicate this judgment to ensure due compliance.
Item number 801.
4th September.
Item number 802.
Your Lordship, the matter relates to the direct recruitment system officer. The direct recruitment system officer before the High Court of Tripura, Your Lordship. The Lordship rightly pointed that an SC candidate was appointed against the seat for ST candidate, Your Lordship, reserved for ST candidate. Lordship, notice was issued 30th of August 2024, Your Lordship. Thereafter was listed before Registrar Court on 14/11/2024. Any day. Because no counter has been filed.
But to give respect, you mentioned an error in an order passed in a matter which was listed on last Friday, Lordship, as item 13. This is a bus matter, Lordship.
First matter.
It was that bus.
Kerala.
Yes, Lordship. In this,
Yes.
Mr. Rajan person who was senior advocate was appeared, Lordship, for a respondent on that day. His presence is marked NP not present, Lordship.
He did not address us.
Lordship, he was present, Lordship. He accepted the notice.
So many laws are present in the courtroom.
Lordship,
But unless you address us,
yes, Lordship.
because as soon as Mr. Giri opened
Yes,
item 30,
Lordship was
he
issued.
said we are issuing notice.
Yes, Lordship.
But some other council got up and said item 55. We also said item 55 goes with it.
Yes, Lordship.
And some youngster got up and said yes, item 55 goes with it.
Lordship.
I don't
Mr.
remember
No.
Mr. Basant addressing us.
Not
at
Basant,
all.
Lordship, Rajan Basant.
Mr. Rajan Basant is also Mr. Basant. Is it
Yes,
not?
yes, Lordship.
Then
Yes, Lordship.
what did you do?
Yes, Lordship.
Drop his second name.
Yes, Lordship. No,
He could
Lordship.
not address us.
He was present, Lordship. He was present, Lordship.
Telling you, there are 100 laws present every day in the courtroom.
And on a miscellaneous day, there's so many people standing with. That's the reason why we put up a notice asking
And
you
what
not
difference
to
it is
crowd
going
the
to
phone
make?
call.
Only addressed and said that we are accepting notice on behalf of respondent number 1, Lordship.
What difference it is going to make?
It's written not present, Lordship. Because,
So you
For
want us,
taking notice also, you need your presence to be
no,
recorded.
it's not that, Lordship. The client won't pay his fee, Lordship. When it is recorded, not
as a
present.
senior counsel, you should not be bothered about fees in one case. For that, you're making a mention.
Item
Please make sure that you get up and address us if you want your name to be recorded, please. These kind of issues you should not even be quibbling over, because we are not expected to note somebody standing at the back and saying, right, so and so is still present. Unless you address us, where is the question of our taking note of your presence? We won't.
And most of the cases, with due respect to everyone, you accept fees in advance. So don't say all this. When a senior
Sorry.
counsel is engaged, normally, I have yet to see somebody who's,
Neither of us recall him addressing us, so. And we don't take note of each senior counsel who's present in court. Sorry,
number 1.
Hey, please, sir.
what happened?
Actually, 28/7 Miller.
We
I have
asked
not
for
filed
it
anything
not-
so far, Miller.
It has not been considered.
Not considered means,
no, it hasn't
Waiting
forwarded.
for the state, your lordship, now it's case being considered under remission, your lordship. Now it has been forwarded to the
Ah.
sessions judge, it's under opinion. Will we need another
It will
8
take
weeks
some
time
time.
to consider this?
8 weeks,
8 weeks.
when comes preparing for.
Miller, now, Miller, one thing I want to appraise, Miller.
Tamil
But
Nadu
now he is in
State
parole, Miller, up to 29/10, Miller.
Petitioners, sorry, appellants, this is a criminal appeal, appellants. Case for premature release or big remission is under consideration, and it may take about 8 weeks for completion of the process. List on
Any date before 29/10, Miller, I'm in parole, Miller, now.
8 weeks. 29/10, very well, on 29/10.
Great, publish.
Item number 2.
Please, sir.
This order was passed on 9 January 23.
Please, Miller. Miller,
387 days delay in
No, no.
e-filing.
Yes, my lord. For that only, minutes on the last date of hearing, your lordships had directed us to file the additional documents with respect to, but my lord, to be very fair to the honorable court.
What
I've
is the
just-
status of the
Yes,
trial
my lord,
now?
this is what I wanted to submit, that there is no improvement in that, my lord, even charges have not been framed.
Then where is?
Then you want him to be in jail.
Considering the fact that the order,
We can do-
included order granting bail to the respondents was passed as long back as on 9/1/2023. And the admitted fact that the trial has not progressed even till date, we are not inclined to interfere with the interim judgment, especially question regarding this. Delay condone. Delay condone, and
Yes,
then you say, however, considering.
Pleasure.
Three,
Item number in 3, I'm for the petitioner. Still nobody just filed the appearance in on behalf of the respondent. We have filed the process fees already on time.
Karnataka, you want to correct?
I'm for petitioner.
Someone seems to have filed a worker, no.
Service is complete.
Service is complete, no worker. Please, there must be a standing counsel, designated counsel. Serve the designated or standing,
Okay, Lordship, please.
and counsel for the petitioner,
Is any returnable date, Lordship? This is a bail application.
designated counsel for the state of Karnataka. List on 10th September.
Item number 4.
Thank you, Lordship.
Please, your lordship.
307.
Okay, and thank you. Both are not good in quotes. You need to be a little more formal. And when you want to express gratitude, Mr. Sachin, we are talking to you. Mr. Sachin, he's gone. A little formal language is required, not thank you. Next, you'll be saying bye at the door. So, all right, very well, for okay. And obliged for thank you. That's all. No hi, no bye. Item 4.
My boss had granted me interim protection from arrest in the interim order, and pursuant to that, I
But-
cooperated in the investigation. That
The
had-
charge sheet had already been filed. Our ROP is wrong, in fact.
No,
By the time
charge sheet-
we granted you this protection from arrest, Charge sheet had already been filed.
Charge sheet is
File
also.
had not been in relation to you. Charge sheet did not name you.
No, my lord.
Now they seem to have filed a counter affidavit.
Yes, my lord.
Yes, your lordship, with regards to the anticipated bail, we are contesting it primarily on the ground there are specific and serious allegations against the petitioner. If the allegation is that he was carrying a pistol as well, he fired at the victim in this case, as well as he broke the bones. And the
The
injuries.
victim sustained a gunshot injury.
No, your lordship, this was
Miss-
gunshot, but otherwise there were fractures in the ribs, legs, as well as the forehead, your lordship. There was a lacerated one.
My lord.
Which
last
And
night-
now, after the order, has he started cooperating?
Yes, your lordship. After the order, we served him the notice. He appeared at the police station.
If
There
my-
were no section 82 proceedings.
Your lordship,
82 now.
not as per my instruction.
58, is it? Under the BNSS, what is the 82 is equivalent to 58?
Keep on converting also.
82 is 84. Very,
My lord, may I make?
more or less the same. 84.
If my lord recalls, I had submitted last time that the informant was accused in the murder of my father, and he's on regular bail in that matter, and therefore this case has been filed as a counterblast, and there's a delay of 15 days in filing the FIR after the said injury, and therefore my lords had orally asked me to submit the bail orders in which the informant was already on bail in my father's murder case. I have those bail orders.
Is that a fact?
Yes, your lordship.
All these are facts.
Submitted.
Yes, your lordship. He was granted bail on 16/1/2024. However, there is one reason with regards to that, is that after the informant was released on bail, the FIR was filed. And there were also previous enmity. So there might be a possibility that
Will again
there's
have a-
there again be in such a situation.
This is informant's bail order in my father's murder case, your lordship.
You may be safer inside here.
My lords, we have not been arrested yet.
Lordship, but there are previously
My
also against the very
anticipations
same,
are from the same FIR, 77 and 78, which are also counterblast to each other.
apart from this.
77 is my father's murder case, 78 is their counter FIR against us.
Anyhow, it's cooperating. Be granted, the appellate is before this court aggrieved by the denial of anticipatory bail by the High Court in relation in connection with FIR number with the details.
Yes.
By order dated 21/5/2025, this court directed that the appellant should not be arrested in connection with the above stated FIR, subject to the condition that he cooperates with the investigation. The state of Bihar filed a counter affidavit wherein it conceded that the appellant appeared before the investigating officer and is presently cooperating with the investigation. In that view of the matter, we find no grounds made out for custodial interrogation of the appellant at this stage. The appellant, the appeal is calling JLR, setting aside the order dated so and so, and directing that the appellant, in the event of his arrest in connection with the above stated FIR, shall be released on bail on appropriate terms and conditions to be fixed by the trial court. We shall also abide by the conditions stipulated in section 482 BNSS.
Item number 5.
I'm sorry.
Person seeking a short pass over the standing count is on her legs in court number 15.
Item number 6.
Objection.
In this case, will not have been released, we should notice.
My lords, I appeal for the respondents, my lords. My lords, we've recently been,
21/7.
Which time?
my lords.
Did you at least pay the fine? Fine amount? What is that? Item 5.
Six tickets. Conviction, it is there. Conviction is there. Suspension of sentence order has been passed. Yes, yes, oxytocin.
Oh, I'm sorry.
Autopsy.
Auto.
Autopsy. However, it's pronounced.
My lords, we will.
There's an imposition of fine also. At least the fine amount you paid or the High Court grants you complete.
My lords, I seek to
No,
obtain
you
instruction.
don't know about that. There's no direction to at least pay the fine amount.
Lordships.
There is no stay with regard to fine part.
Well, otherwise also it's one of the ingredient in manufacturing.
Yes, yes, we have fourth grade ingredient. Just thereafter, we have
Fine,
converted into alcohol.
He is entering appearance now. Land counsel for the respondent seeks some time to file a counter affidavit, which should be done without fail within 2 weeks. Whether thereto, if any, may be filed within 1 week thereafter, based on 24th September,
The receipt of 24th can be on 25.
25th September.
Great.
Item number 7.
Item 7. You are appearing to the state.
State.
Counter is not filed. Though.
Yeah, it was filed yesterday. It might
That's
not.
fine. Does he have any past cases also?
No,
25 kg.
Past cases?
no, there is no antecedents.
You've completed the investigation?
Yes,
Charge sheet is also-
yes, yes, on 24th, yeah, 24.
In your counter, you said that he doesn't have past cases?
We have, there is no mention of
Any past cases?
any.
You have instructions that there is no past cases?
Yes, 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 counter affidavit.
Anyone for the petitioner? Pass it over, let us see if it comes.
Item number 8.
You filed a letter seeking an adjournment.
This counter has been filed yesterday evening, I think, your lordships. I have received a copy at my learned.
Why do you want to file a copy of the FIR again? You already filed it.
Because it's not on
You
record.
filed it earlier.
No, it's an inquiry report we had filed earlier. Your lordships has asked for the
FIR also. So you-
FIR.
You need to
And
file these.
Please, your lordship, because there is many things which
It's
has
estimated
happened.
after a week, Malus. In fact, there is a development in this case.
We don't have a counter also.
It was filed yesterday.
And very technically, they have hided the FIR, which is the main part.
There is an
And
order.
counsel
Malus.
for the
We can
petitioner
place it on
seeks
record.
an
That's not a problem. Malus.
By way of.
In fact, Malus, one of the co-accused
To
is
enable
being-
him to file additional documents, we are further informed that, don't say further, we are informed that the state of Chhattisgarh has filed a counter affidavit yesterday, but we do not find the same on record. We will still to verify and do the same.
In
By the
the,
next date of hearing.
after
How
3
much
weeks,
time do you want?
after 3 weeks, because
There is some
of.
urgency in this because Malus, what is happening
Let
is
me, let
a
me.
co-accused, his anticipatory bail was dismissed, Malus, last week. That order was being used before the High Court by everyone because it's a scam, Malus, it's a Bharatmala scam in the state of Chhattisgarh, Malus. And because of that order, High Court has been granting interim relief, Malus. In the
That's another case. Let me say something.
Same.
He's continuing, he's not
The
aware.
court has been granting anticipatory bail to other.
Interim relief, Malus, in a lot of matters, Malus.
Anticipatory bail or regular bail?
Regular bail is granted.
Anticipatory bail matters.
Anticipatory bail is.
Yes, Malus.
It's a regular bail. Main accused has been granted.
was placed on the interim order of this honorable
This
court.
one.
That bill and
After 3 weeks, your
This
lordships.
on
Please have it next week, Malus.
25th September, we make it clear that the High Court shall not extend the principle of parity to other co-accused on the ground that interim protection has been granted to the petitioner without examining each individual case on its own merits and in accordance with.
Fair enough, here. Much fair enough.
Number
In the meantime, I may be directed to file rejoinder. Please.
Rejoinder, if any, may be filed by the
And interim order.
interim order shall continue.
Please, sir.
Item number 9.
Here against anticipatory bail dismissal, my lord. There was a
This
proclamation.
order was passed on 24th January 24.
Yes, my lord.
There's a delay of 438 days. Criminal matters, we tend to be more liberal. But look at the number of developments after passing of that order. Why should we entertain this? We need to go back to the High Court. Did you see the things that happened?
My lord, then
There will be the husband surrendered, then thereafter he's granted bail. You did not appear, warrant has been issued, thereafter 82 proceedings are initiated, you file a writ petition against that, you obtain a stay. So many developments have taken place after the passing of the.
then I may be allowed to withdraw this.
Turn counsel for the petitioner seeks permission to withdraw this special petition, preserving liberty to the petitioner who approached the High Court Public Sessions Court, if sufficient grounds are made and therefore the petition is permission granted to the SLP is accordingly dismissed as withdrawn with the liberty of the state.
Item number 10.
After your lordship granted protection on his petition has been called for 5 times. Even 2 times the statement has been recorded.
Anyone appearing?
Stand to the state, there are some antecedents.
The antecedents
You need to file a counter, you filed it. Counter is filed.
There are page 7 of the
You say
counter.
that he's cooperating.
Yes, Malas, we have said so. Malas, he was the linchpin of the entire transaction.
But still, some, it seems to be a civil dispute, there's some civil litigation is also pending.
I may, Milot, I
You are
was,
saying for the complainant.
Milot, not for the complainant, but the power of attorney holder of the complaint to whom? In the High Court, they said I do not have a valid power of attorney. Milot, I have presented it, I have filed my impeachment of 51 acres of land of a person, Milot, mutated wrongly by saying that the mother and the sister are dead. He is the sole legal, and the land goes to his.
The issue.
No, not only mutation, Milot, the
Some
land.
forged documents according to.
Land is transferred to his
Your
family
civil
members.
litigation is pending. Why should-
Malas, he claims that there were no other legal heirs.
Let it be.
Look, the land has been transferred on the basis of these documents to his family members, to his.
Transferred?
Yes, Milot.
What do you mean transferred? Mutation.
Yes,
It's
mutation.
only revenue records. It's not that.
He says a hibanama, a gift, oral
It's
hiban,
just a name being entered in the revenue record.
on the basis of a gift deed, Milot.
So be it.
Look,
What difference does it make? It doesn't confer title.
under the Mohammedan law, it is a valid transfer.
Mutation, does it confer title?
Milot, kindly,
If he wants to pay tax to the government by getting his name mutated, so be it. You continue to be the owner, if you are the owner.
Milot, kindly see for a minute the
That
SLP.
will be resolved in a civil suit only.
Milot, the problem is this person, Milot, he says he was the person who was there. He said, I was only the
Is he a
signatory.
hardened criminal? If he is out, he'll start killing people.
Because there are two cases.
He'll involve himself in a drug trade. What is this?
Because he has been involved in 2 more cases, because as per the states,
Mr.
Under
Abdul Mohammed
NDPS.
Prasad, not in this case.
because only 2
Every-
things.
Please
No,
grant
no.
it. The evidence is before this court and you guys denied of anticipation by the High Court in connection with this complaint case or
There is an FIR.
connection with FIR in response by order 17/7/2025. This court granted him protection from arrest subject to his cooperating with the investigation in connection with the frustrated FIR. Counter affidavit having been filed and counsel for the state of Madhya Pradesh concedes that the appellant has joined investigation and is cooperating. So, we are of the opinion that custodial interrogation of the appellant is not warranted at this stage. It relies upon the allowed setting aside the order waiters also. Directing that in the event the appellant is arrested in connection with the crime of this also. We shall be released on bail.
But he may continue
Terms and
cooperating
conditions
with investigation.
fixed by the transfer. The appellant shall continue to cooperate with the investigation and shall abide by the conditions stipulated in section 482 PNS.
I'm so deeply.
Item number 11.
With permission to file minutes, give appearance physically minutes. Interview.
In item number 11, and I am appearing, but petitioner in jail from November 2023, my lord. No incriminating material has been found from the possession of the petitioner under the NDPS Act, my lord. Only allegation is that there is one country.
There is
made-
one case against you already.
Two cases, my lord, 2 cases, wherein he is on bail, my lord.
Those cases are under which act?
2 cases. Not he is on bail,
Those cases are under which act?
NDPS.
not in the.
One name under.
No, my lord, in the robbery case. That was the 2 cases. That was of robbery, my lord. The antecedent, my lord. In this case, my lord, he is not, no incriminating material has been found, my lord, from the conscious possession
Page
from the
2,
petitioner.
Page 2 of the order, para 5. Criminal antecedent of the petitioner is relating to NDPS Act. You think that we don't read the order or we don't
No,
read
the
more?
criminal antecedent of petitioner is relating to NDPS Act in the light of this. Not, it's wrong, because I have instruction.
Mentioned in the order.
But I have instruction from the client, my lord. 2 incident is
Not
there, my
going
lord.
to wish it away. Even if he wishes it away with
No.
all his might.
If you
If
lord,
it is an NDPS case, it will be an NDPS case. That is what the High Court has recorded. Why should we doubt what the High Court said? You have a NDPS case
The robbery, two cases robbery
up your
cases.
sleeve,
If
and this case again involves a commercial.
Not if your lordship may kindly have page 16, my lord, 4 line from button, the FIR, my lord, the allegation. 4 line from bottom, my
Well,
lord.
you seem to have an antecedent.
The 2 years, my lord.
Enactment.
Not in the,
27th year he applies.
not in the instant case, not in the instant case, the robbery is made only in the.
Delayed note, however, we find no ground made up to interfere with the good judgment passed by the High Court. So a shape action is according to this.
This is a regular bail application, my lord. My lord, there is
Past cases,
No criminal antecedent.
no criminal.
No criminal antecedent, my lord. There is no recovery from me, my lord. The recovery is from two persons, Bahadur Kude,
They named you.
and they named me, my lord.
And who is this Vikash Rajhans?
My lord, it is in my memorandum, my lord. What I stated before the police, that I transfer 1,30,000.
We'll issue no.
Submitted the police.
No, no. I notice returnable on 8 October, submission to effect.
CBO.
13.
May I please, one of the petitioner seeking cancellation of the bail, my lord. Section 37 has not been.
You at least have a chemical analysis report.
But that's not the allegation here, my lord. The allegation is that he was found.
You destroyed.
Not
the
even,
contraband.
not this honorable court.
No 52A compliance.
Like, does it, your lordship, it doesn't.
Bharat Ambale is one issue.
Yes. So the court
What
also.
do you have? Even Bharat Ambale says 52A, if you not complied with the.
There are other
procedure,
conditions because it is
that will by itself not be sufficient, but you at least need to have something.
Lord, I have
to do that.
recovered-
You at least have a chemical analysis report.
Well, that's not the ground on which the High
Do you
Court.
have anything?
Lord, my.
What do you have?
Lord, our content, the court puts it on the ground that he has
Sir,
been.
please
Answer to the question.
When you have recovered 1200 kg of cocaine,
Yes.
you must have sent a sample to the chemical examiner. Where is that report?
Lord, I look into that, but I don't
must.
have it right now.
1,490.
1,490 as against 100. No, it is far in excess, my lord.
What do you have though?
Lord, that.
DRI destroys the
No, your
cocaine.
lordship's query is correct.
Did you at least get it chemically analyzed? You
I
at least
need
have
to-
a chemical
that's
analysis
coming
report.
from the SLP, my lord, because it went on the ground that he was
Forget
incarcerated.
about the
for-
ground. Whether do you have that report
No,
or
it
not?
must be there, my lord, but I don't have.
There is
right
no
now.
question.
It's okay.
Lord, your lordship
If
is.
you have nothing at all, why should you?
No, I'm
just
saying I
wait
don't.
listen?
No,
For
I-
what reason?
No, I'm only telling
You will
you.
ultimately fail because you have nothing.
Lord, I
You don't
We are
get the
1990
material before the magistrate, you don't get it identified, no.
Milord, that's not the allegation on which he
Nothing.
got the relief, Milord, your lordship.
52A violation is clear.
Milord, 52A, your lordship.
52A violation, if it is there,
it is-
then you need to at least have sufficient. Shall we?
And Milord, I do agree.
No,
Milord,
but
I
if
do
you
agree. What,
destroyed everything, what is the evidence that it was cocaine?
Milord, I do understand that.
If you do understand,
Milord, then
please tell us.
the only thing I can't tell offhand, Milord, without
Then we are
instructions
sorry.
from the.
Bharat Ambale says,
Yes.
satisfy the court that such non-compliance does not affect its case against the accused and the standard of proof required would be proved.
I do agree, Milord.
What do you have is what we are asking you, we are not getting an answer. You don't even have a chemical analysis.
Milord,
report.
Milord, I'm not aware from the facts of
That
this case.
you
I
have
can't
to have
visualize.
There's no
That's only
question.
difficulty.
Delay condoned, however, we find no good ground and reason to interfere with the interim judgment passed by the High Court, especially questions according to this.
Number 14.
14, my lords, I'm requesting for a password.
We are not sitting in the afternoon, so subject to availability of time, otherwise you'll get a date.
Please, please.
Number 15.
Please, lordships.
Yes.
This is a case of anticipatory bail, my lords. I have been named as an accused in the FIR. I was neither the maker nor the checker.
No, but
And-
you received money in your account.
Lords, I have received money in my accounts. I'm not disputing this. The issue is, lordships, there is this person checker, Satnarayan Bhagat. Lordships,
To pay,
he is
you said you're willing to deposit the amount.
the amount, lordships. We'll deposit it, lordships.
That by itself might be an indication of guilt, is it not?
No, I'm not on that aspect. Lordships, I will show you what the issue is. Lordships may kindly come to page 62, 63, lordships.
You will come, this is some public scheme, is it not? Janani
So
Suraksha.
Janani Suraksha Yojana, lordship, I will show you the issue. What is the issue? Lordships, lordships,
Well, you said you will deposit this 96,600. So let us
grateful, we will deposit it, lordships.
in ground JJ, the appellant, sorry, the petitioner, ground JJ raised in the specially petition, the petitioner offered to deposit the sum of rupees 96,600 without prejudice to his submissions, subject to the petitioner depositing the said amount within 2 weeks.
4 weeks, lordships will have
Till
to.
4 weeks, you won't have the benefit of the anticipatory bail.
Lordship, but 2 weeks, 2 weeks. My lord, the issue is they are poor people, my lord. They are daily wage
You
earner.
must be having the money ready of this.
No, lordships. I will tell you what the scheme, what the scam has happened, lordships. In this case,
You've not spent it all, then you might have it, so you can copy.
no, lordships. I don't have the money. I don't have that money.
Should not
The
offer
checker.
of depositing unless there is something more to be said.
No, lordships. I will show you the issue, lord. If that be the case, lordships, I will show you what has happened in this case. I am not the person who is authorized to make this
Transferred into
payment.
your account is 19,600. Amount transferred into your son's account is 26,000. This is a matter of record. This is
Please, my lords, no dispute on that. Please, my lords, I am not disputing it.
So why are you taking all the this public scheme money into your own account?
My lords, no, lordships, I will tell you what the issue is. Lordship, I am actually a daily wage earner in this matter.
Subject to the petitioner depositing the sum of rupees 96,600 with the state of Jharkhand within 2 weeks from today. The petitioner shall not be arrested in connection with crime number so and so, subject full stop. He shall, however, join the investigation and cooperate. Join and cooperate with the investigation.
Great.
He shall also abide by the conditions stipulated. Based on 8th of February. Yes.
May please, sir. Well, the petitioner is in custody for more than 2 years, 8 months. Neither the notice under section 50 nor the
memo of arrest is clear enough, page 28. What more do you require? It gives the details of what has been seized.
Because this is also 30, this year, like your lordship's Pankaj Bansal, where your lordships have held.
Beyond this, what more is required for a ATPS offense?
The material that constitutes the ground of offense, my lord.
If you are keeping all these drugs in your house.
Well, that, my lord, it is not, he came later.
This is your house, though.
Well, that is the allegation, my lord.
It's not your house, also.
No, that is the allegation.
You want to give up your house for the sake of mistake?
The person who was in the house, he has been granted.
The house belongs to you.
That is, my lord's instruction is no, but may I say this? I came later at point of time.
Allegation is that this house belongs
that is the allegation. Even the other co-accused says, my lord. But my lord,
look at the quantities.
Well, that I agree, my lord. But your lordship would
153 kgs of cannabis.
I am raising, my lord, that
methamphetamine tablets.
179. My lord, the High Court.
Heroin.
No, I am not.
Then cough syrup. So you are catering to all levels of drug addicts.
May I say that?
Right from the starters, cough syrup, right up to meth.
May I only say, my lords, in the co-accused, my lords, who was in the house at page 98 and 108, the High Court grants bail on the ground of failure to communicate as required.
He's the real one, Breaking Bad.
He is the main person who was in the house.
With these kind of drugs,
2 years, 8 months now, my lord.
The section 50 ground will not stand at all, given the memorandum of arrest, which gives the details of the
That is why, my lord, that is why I started with 2 years, 8 months, my lord. And the co-accused one was on parity.
Well over the commercial quantities, each and every one of them.
My lords, the co-accused have been granted.
Each and every drug about the commercial quantity.
If your lordship just have a look at 108, my lords, at the order of the High Court pertaining to the co-accused, it starts at 98.
Was he there in the house at the time?
Yes, my lord. He was the first person in the house. And para 18 at 107 relates that only 3 witnesses and the...
He was a co-driver. He was not in the house.
No, he was, my lord. If your lordship sees the FIR.
Whatever co-driver means.
There are 3 accused. He is the person who was first found in the house. And His role is, Your Lordship will find it para 17 in the chart sheet, page 58. Page 55.
But your earlier SLP has been rejected by this.
Because, my lord, I tell your lordship, he was granted bail on 15th of May, and I reviewed the SLP on 19, 4 days thereafter, perhaps because of the order of the High Court in the co-accused case. So the order doesn't say that, 110, my lord. But just 4 days prior thereto, he was granted bail, the co-accused man.
Change in circumstances.
Ground of arrest was not urged in the earlier round of litigation, my lord. Only 4 witnesses have been examined as of now out of 12, my lords.
The other man at least is a driver, therefore the grounds of arrest need to be a little more clear. But if this house belongs to you, because where do you say that the house doesn't belong to you?
That I don't think we have made an
You're
effort.
not. That the whole point is the house is yours. So once the house is yours, the implication is that these are all yours.
No material.
Your material.
My lords, I don't want to get into that, my lord. On parity, my lord, your lordship may
Point
consider.
of distinction.
My lord, your lordship may give a long returnable day. Maybe, my lords, because there is parity, my lord. One of the accused on 50 has been granted bail, my lord. My lord, the pertinent to what fell from your lordship, page F.
Yes.
We don't say that the house doesn't belong. Now where?
Wanted the petitioner to go down, that they invited the petitioner to the house.
Where do we say that?
Some of his business drivers. Don't say that.
One, no, my lord, I'll just.
Goes from where? Oh, I see, you said it at the top.
Yes.
Page F.
Page 51 also.
Page F, he says.
Page 51, this part of chart. The confirmation is awaited so far as ownership of house is concerned.
Specific government made by the petitioner that the house from where the drugs were seized did not belong to him, comma, issue notice, turnable on 8th October.
Deeply applied.
Service shall be effective for all months and 20.
Item number 17.
Made, please, your lordship.
Yes.
Lordship, this is an anticipatory bail, your lordship. Lordship, other two co-accused persons, your lordship, have been granted regular bail, lordship.
3 past criminal cases.
For the 3 criminal cases, your lordship, and on those cases, I am on bail, your lordship.
What were those cases about?
Lordship, related to the liquor.
Liquor business.
Lordship. Your lordship, in this case, your lordship, this is broad daylight case. But in lordship, no independent witness.
In the business.
Please, I will.
Notice returnable on.
Tell him to stop on this.
Notes, I'm appearing for this statement. Notes, I accept the notice. Notes, I will file counter.
Notice has already been issued.
No, this is fresh question.
Issue notice returnable on 8th October. Learned counsel, Mr. So-and-so, learned counsel, who is present in court, accepts and waives further service of notice. Accepts and waives notice on behalf of the state of Bihar. Notice need not be served afresh on the state. File your counter. These past cases is one thing, but some chowkidar is the one who's supposed to have identified that he's one of the persons who ran away. Beyond that, if you have nothing, then you're obviously pinning it on him because he's got past cases. Normal procedure for the police is if someone already has a history sheet, then they dig it out And if they don't have the accused in a particular case, it's very convenient to pin it on that person. So other than the Chowkidar's identification, do you have anything? In the meanwhile, the petitioner shall not be arrested in connection with FIR number so and so, subject to the condition that he joins and cooperates with the investigation.
Much of
Item by 18.
May please. Melody, your lashes.
Have you filed an undertaking at least?
Yes, I think everything.
Undertaking, you have not filed a copy of the undertaking?
Not filed and 17, my lord.
Where is the undertaking?
We had moved the application.
Undertaking, we said undertaking will be filed within 2 days or something.
Well, I can check.
Lordship's accepted
Not
3
filed via
days. 3 days. Directly in contempt.
3 days.
That's right.
So you did not even file an undertaking?
That's right.
Within 30 days, you filed the application.
17 you find no grounds made.
One second.
Extend time
If you have respect
in the light of
towards the order of this court, then
admitted
we also
fact that
sorry
the
can't take more duty.
applicants did not even file an undertaking in terms of the order passed by this court. The application is accordingly dismissed.
Whether we are last should give some time to fight.
Undertaking.
Item by 19.
Well, it's key concurrent findings in my favor.
But section 21(1)(a),
Malutz.
let us see the provision.
Malutz.
Where is that? Provision of law.
You filed a copy of it somewhere.
That is also reflected.
It's in the page 6. Page 6.
Page 6, Malutz.
But look at that clause C. Any building used or intended to be used as a factory within the meaning of the Factories Act.
Malutz.
So nothing in this act shall apply.
Malutz.
Now you proceeded under this act, but this building which you had let out was used as a rice mill.
Malutz. Malutz, may I just.
Now, only one issue would save you. Even if it is used as a rice mill, the number of workers were less than 10, then it wouldn't be a factory.
Malutz.
But we don't know how many workers there were in 1970.
Malutz.
How will you prove it also?
Is this?
How big is this rice mill? Is it a small?
Malutz, the plot area is about 5,200 square feet. And when the lease was signed in 1970, Malutz, which is the lease deed agreement reflected on page 34.
You're getting 100 rupees per month at that.
That is also, and para 10, Malutz, on page 35, it says the first party is in the possession of the said above house, and the first party has fitted the machines in the said. So I only give the land, Malutz. The machinery was subsequently added by the.
No, but the provision.
Where is your lease deed?
You gave a building.
Is at page 34.
You gave a building though.
No,
not land.
Only the land, Malutz. Yeah.
Did you give the land or building also?
Or the shed is constructed afterwards, Malutz.
The lease deed only mentions the land then.
This is
which page is the lease deed?
34, Malutz. It's para 10, if Malutz have a look. It says the first party is in the possession of the above said shed of the house.
Newly constructed.
Newly constructed, Malutz. And the first.
It is a building.
Malutz. And the first part.
And 21(1), that exemption clause requires any building used or intended. It doesn't say that you need to provide the machinery also. If you give a building which is either used or is intended to be used as a factory, it stands exempted from these provisions. And you move under this act and ask for eviction, you succeed all through. But if ultimately it's a jurisdictional issue, obviously you will have to fail.
But if I just read, this is section 21C, Malutz, of the Act.
Yes.
But it says any building used or intended to be used as a factory
within the meaning
of the Factories Act, where the plant of such factory is leased out along with the building.
Or any building.
Or any building. In my case, Malutz, I have only given the land.
You've not given the land, you've mentioned in your lease deed that it's a newly constructed building.
Malutz. Also, Malutz, may I just probe
unless you're able to show that they had less than 10 workers at that time, then it won't be a factory.
But for that, I'll seek instructions, my lords, for this particular query.
Or a floor mill or whatever it is of action.
But let me take instruction because my lord, 1970, I'll have to speak to the client. my lord.
Find out, when counsel for the petitioner seek some time to get full instructions as to the nature of the rice mill activity. Not rice mill, is it? Floor mill or rice mill? I thought it was a rice mill, but my brother says.
Rice mill.
Rice mill only. Rice
In the
mill.
time for judgment, they will take floor.
Floor mill, rice oblique floor, we'll mention both. Rice oblique floor mill activity that was undertaken in the least constructed area. How much time did you require?
Well, it's 2 weeks.
List on 15, 22nd.
So very good.
Similar SLPs.
Yes, I'm paying for this. There is no.
There have been rights. That it will not preclude you from initiating.
Great.
No, sir. Apart from the fact that by way of an interim order, final relief was given, page number 25 in the review petition and before the review court, page 25 for a minute.
Let us see what you said in your 28/8/23 communication.
Look, it is not a communication.
Whatever it is, let us see what you said in.
Because it's not a communication. Because it's a computer block. It's not an X because it's a computer block.
That is the whole basis of your case.
I understand, because I also took instruction. What we do is we issue e-passes for those in the
what basis you say that they are not fitting into the definition of an affected family?
Because there are two reasons. One, in our written statement, we specifically took the plea lots that there is either giving them this truck for plying or giving them direct employment. In our written statement, we directly took the stand that one of the family members have already been employed at that point of time.
This Devi's family.
That's right. That is one. In the written, apart from this, there's one more development. Would your lordship kindly see page 25 of the review order? We went back in review because the High Court in similar petitions took the view that the privity of contract is between the company and the cooperative society.
Issue. That is the other matter where we had confirmed it also.
Look, similarly, here also we have not taken direct action.
Stop their truck.
Look, so
it's obviously personal to them. Look, when you say that the society has to fight on their behalf.
Because in those cases also, they are all members of the society. In those cases,
you came up with some policy change. There we said that it is for the society to object to whatever change. Here you stop individual trucks of particular persons. 7 suits are pending.
They are also the same thing. It is not the society which came up in
that ground.
Would your lordship see even there also it is not society.
Where did you raise this issue that you've already provided a
written statement
to a member in the family?
Written statement.
And how does the court deal with it?
It's not been dealt with.
At all?
No. No finding. Para 3, page 119. 119 written statement.
119.
Look, in any event, this is an interim order by way of
the plaintiff is the president of defendants too. You don't say that he's been provided. He's the president of the society, is all you said.
Oh, sorry, para 7, my mistake. Para 7, 6th line. But the family of the plaintiff was availing both by working in the company and by plying trucks in the society.
What employment was given and to whom? No details.
We have to take this. Look, this was a simple.
Nothing at all. This is your written statement.
This was my written statement.
So blissfully vague.
Look, would your worships appreciate one more thing? The only
where is the policy that either truck or employment will be provided?
DM's order page 81.
80?
81. DM's order page 81.
But obviously, if you had provided employment to a specific member in the family, you would have named him and said he was appointed as so and so.
83 para 2. 81 DM's order starts 83 para 2. Look, in any event, look, this is the final relief by way of an interim order. It's a simpliciter suit for injunction without even calling it to question. Would your lordship kindly see the prayer in the suit?
This is only an injunction order.
Look, the final relief is this.
Still pending.
Look, the final relief is this. Kindly see 112.
You continue to use the trucks. What harm?
Look, kindly see for all three perspectives.
Before this court, I have not mentioned that X is employed in the factory.
If that was your ground, you've not even taken that ground.
We'll also just stand it over to the next week. So
I've already said this again and again, this piecemeal building up of the case before us by taking a cue, not the proper way to present the case before the.
Can I just put it a little differently?
You need to at least know what your case is and give all material in support of your case.
Can I just put it a little different? Can I just put it Your Lordship will permit me to do that.
No, we are not going to. We've already dismissed several cases on this ground. We are not going to.
No, I'm not asking for it. I'm not asking
your case from date to date.
No, I'm not asking for that. I'm not. Kindly see this place. My MOUs with the society, Millers. In all the other cases also, Millers, it was the society.
Give benefits to individual members of the society and then you take it away from individual members, they have a personal.
Look, that was exactly the order the High Court passed.
That is not the order.
Can I just show that? Can I just show that?
We have our own order.
Look, there also you like.
We are not inclined to interfere. This is Ambuja Cements. Anita Sharma versus Ambuja Cements.
That's what it is. The individual members who came there also. It's not the society.
That was not
a
individual cause of action.
Can I just show that? Would your Lordship kindly see the High Court order on this?
However, we find no good ground and reason to interfere with the interim judgment, especially petitions that have been dismissed. 22. The matter is sent back to the magistrate. Why should we interfere?
That is true, my lord. The last, but my lord said after a gap of 8 years, my lord, and Pradeep Udia's judgment, 21 Supreme Court must also say that there
no prejudice caused to you.
My lord, that is kept open and the court has
interfere with the interim judgment, especially if petition is accordingly dismissed.
Item number 23.
Lords.
There is registered against me for resisting.
You tried to demolish the wall.
Because there was a direction, direction by the.
Not to you.
Not to you.
You were not asked to demolish.
No, I have a difference. Wall is
tried to demolish the wall. That is the reason why we filed.
The wall is there.
He's got a status quo order now.
No, but that is also dismissed. That
very well. That's gone. It is for the authorities to take action. Why do you take law into your own hands?
Not even an attempt made by
the. That is the allegation. That has to be in
the report of the regulating authority. If your lordship would say the wall is there.
Question of quashing it. He alleges that you tried to demolish the wall.
As a secretary, resisted it, my lord.
If you did try to do that, you have something to fear. If there's nothing, then obviously a nil final report will be filed. Why should we quash the FIR for that? Sorry, Counsel.
I made a representation also.
Good ground and reason to interfere with the interim judgment passed by the High Court, especially if it's the parliament dismissed.
Item number 24.
Oh, my lord. The High Court modified the conviction to 304 Part 2 and sentenced me to 10 years, my lord, which is the maximum. I have already undergone 9 years and 5 months. So
you wait for the rest of the period.
That's fine, my lords. I am only making a very limited challenge.
The flat is yours. There's enough evidence to show that the body was collected from the bathroom.
That's not
your flat.
I'm making a very.
How do you explain the presence of this dead body there?
I'm not challenging any of that right now, my lords.
Then what more do you want?
The only thing is, as far as the fine is concerned, my lords, I have been imposed a fine.
That is the recovery proceeding. Not that you will
A1
punishment.
A1 and A3.
If you have property, then
just
recover. This lady has to be recovered and she lost her husband.
Yes, A1 and A3. They have been imposed a fine of 25,000 and 3 lakhs.
Flat is yours. Where you kept him for how many days? 28 February 2016.
But the role is
the second.
The role is the very same. The role of both of A1, A2, and A3.
Person was in your house. You kept him inside the house. Beat him black and blue to the extent that he died.
So did A1 and A3, my lords. So at least as far as the imposition of fine is concerned, there should be some parity, my lord.
This is compensation, not even fine. This is compensation, and recovery proceedings have to be initiated against you.
Very well.
Delay condoned. However, we find no good ground and reason to interfere with the interim judgment passed by the High Court, especially petition is accordingly dismissed.
Item number 25.
Well, I'm seeking a short pass over.
Item number 26.
Yeah, please, lords.
Where is the deposition of the victim?
Please, lords.
Not filed.
It is filed, my lord.
Which page? Not 161 statement
164.
Before the court, before the trial
examination, my lord.
Before the trial court, where is the deposition?
It is
not filed. I could, from your index, there's only mention of 161, 164. We've
In the
not
cross
filed her
examination,
deposition.
only that much has been.
You have not filed her deposition at all. Have you?
In fact, father and the prosecutrix, both of them have spoken against you.
There is no allegation against me.
Para 12 of the impugned order. Upon perusal of the impugned order, this court finds that the parameters laid down so and so. Once the prosecutrix, in her deposition before the court below, has clearly and categorically implicated the applicant for conspiring with the co-accused for committing the crime in question.
No such document was.
You don't even file the document. This
No, it was
selective filing of documents.
No, my lord, there was nothing before the High Court also.
The High Court refers to the deposition
Lord,
of
the High Court says it is a prompt FIR. There's a 15-hour.
prosecutrix deposition is referred to, which you have conveniently chosen not to
Lord,
file.
then please give me.
We have already said this kind of selective filing of documents, building up the case from stage to stage. We are not going to.
Lord, please give me just one.
Sorry. To take condone. However, we find no good ground in these to interfere with the impugned judgment passed by the High Court, especially if it is accordingly dismissed.
Number 27.
Please, your lordships. This is for 23 years, the trial.
111 weeks was asked for, time is granted till 31.
All I am submitting today is, your lordship, no extension should be granted.
No.
That is all I am.
2002 FIR, no doubt, but let the trial complete.
So therefore,
we find no good ground and reason to interfere with the impugned judgment passed by the High Court.
Your lordship may,
petitions according to this.
your lordship may just say, let no extension be granted. That is all I am asking.
We are not going to bind the High Court or the trial court with that kind of.
So your lordship, 23 years.
Maybe so, but perhaps because of the voluminous material there, we don't know what is delaying the trial. Any of the High Court has fixed that date.
So all I am saying that
No,
whatever
we
date
are not
has
going
been
to say
fixed,
anything further.
your date has been fixed, that may be.
No.
Item number
Very
28.
Lord, on my application, which your lordship finds at page 141.
It is the IO who asked for this lien and debit freeze.
No, that's what I'm
It
saying.
is the IO who says I'm satisfied with the person.
No, but my lord, that's what, my lord, there seems to be some collusion. In fact, what happened, just kindly see it. Page 141, my application is still pending. I'm the complainant, my lord.
He did take, on your complaint, he wrote a letter to these banks asking for a lien.
So there was no collusion at that point of time.
My lord, I moved the magistrate. My application is pending. Repeatedly, the reports are called. May I show to your lordship all that, my lord? Page 141 is my application. Your lordship may just kindly see. All this is not even disclosed to the High Court.
You were not there before the High Court?
No, I did not come to know of this order, my lord. On the very first day, he makes a concession and this is allowed. And my lord, my application is still pending. What happened?
On the very first day, the IO was present before the court.
Yes, my lord. That is, my lord, because they are served the advance copy. The IO may not be out of place, my lord, because they are served advance copy. So therefore, his presence.
Even after advance copies, even when the IO is called, you very well know they don't turn up. So if the IO is so promptly available, that itself is a reason for.
Yes, my lord, he made a statement. Your lordship is right. Para 11 records that. And my lord, what happens to in fact, my lord, my application was, you kindly see what the transaction is. My partner, my lord, he dupes me during investigation.
On the first date, this was.
Yes, your lordship sees the impugned order. It says it. Just kindly see the impugned order.
25th of October.
Your lordship may have the impugned order, you know.
You're
I'm
informed
reading
that
from
the
it.
impugned order was passed on the very first day. Mention this.
Para 7, your lordship sees issue notice.
Impugned order was passed on the very first day of the application.
Lord, may I say one thing? Your lordship may see para 7 of the impugned order at page 3.
Issue notice for this.
That's why I'm saying it is first order. My lord, I was not there, so I do not know.
Petitioner was not made a party.
First effective hearing. First effective hearing.
The first
effective
date
hearing.
of effective hearing was don't say first date of effective hearing, and the petitioner was not a party there. Issue notice, delay condone, issue notice returnable on 6th of June.
Item number 29.
Wait for you.
My lord, in this case, trial court acquitted me for offence under section 138 of Negotiable Instrument Act. The judgment of acquittal has been reversed by the Honorable High Court.
Does not go with this. That's something wrong in the process. 55 doesn't go with this.
Old remarks.
It's not.
Old remarks.
Some old remark is. You don't have to try that. Yes.
Yes. My lord, may I, the entire controversy is involved is with respect to the whether I
You
discharged.
did not even respond to the 138 notice.
My lord, that is a fact that no reply
But
was
would you
given.
not, would you
No
not
reply.
have responded if it was your case that a blank checkbook, signed checks were stolen?
My lord, keep it aside. But
That is the most
Yes,
crucial.
yes,
Why
yes,
would we
yes.
keep it aside?
No, my lord,
If you had something to say in the
I
response to the notice,
I didn't respond.
something
That
valid to
admitted.
say, you would have automatically said it. The High Court records that you did not even reply to the
Right,
notice.
but my lord, the complaint which was filed by the complainant and the evidence examination in chief filed by the
It is a
complainant.
signed check,
It's
you do not
completely-
deny your
it
signature on the
completely-
check. You do not deny your
My lord,
signature.
the question, I'm not denying the
Presumption
signature.
arises.
I'm not denying the signature, but the question is about the burden of legally enforceable debt. My lord, is all about the legally
The fact that
enforceable.
you did not reply to that notice weighs very, very heavily.
My lord,
against
but
you.
there are material
And-
contradictions
And
in
the fact that
entire
the
evidence.
check is signed by you is enough for the presumption to kick in. Therefore, the.
My lord, no,
obviously justified.
that burden,
Sorry,
I have repeated my case in the cross examination. If your lordship allow me to go through in the cross
You
examination.
say that he didn't have enough money to
My
lend
lord,
you.
the lady is widow.
That doesn't mean that you get
No,
away with
no, she is
giving a check and
not-
then. Sorry, Counsel, we are not inclined to interfere with the impugned judgment passed by the High Court, especially petitions accordingly dismissed.
Item number 30.
Much obliged. My lord, there is a delay of 141 days.
Delays there?
Yes.
Oh, it's a delay, however. Yes.
No,
30.
May I please, my submit in this matter. Last time your lordship granted me time to file some additional document.
Not file?
If these are ready and you have translated it, you will file it with having minded.
Are you also claiming that the petitioner was a juvenile at the relevant time?
The report we have asked, but no certificate about that is available, but other depositions are available, we will file.
Deposition form, no school record, nothing at all.
That-
Never went to school.
My lord, that we have asked them, but because since he is in jail, his parents are not able to manage these.
Parents don't know whether he went to school also. Own
That-
parents or?
That we will file, my lord. In the meantime, kindly have it next week.
Counsel, seek some more time to comply with the order dated 18/7. To take steps, you say, don't say comply, take steps in terms of the order dated 18/7/2020, based on 13th October.
Much obliged.
Number 31.
On current finding.
Yes, madam. What is sold was a property.
Boundaries will prevail.
My lord sees page 47.
And-
He was my lawyer. He was my lawyer who wrote the document, sold it in favor of his wife.
Where is the original document? How does it show that the boundaries are tampered with?
No, not tampered with, my lord. He drafted the sale deed.
You signed the sale deed, you knew what the boundaries mentioned in the sale deed were.
My lord, I have to say this, my lord, if my lord will permit me. The sale deed clearly says that what I sold was the property.
Survey numbers is one thing. Settled legal position that boundaries will prevail over the
quarreling on
description of the property sold.
My lord, I'm not quarreling on that.
Then where is
If
the
my lord-
boundaries? You admit that the boundaries show that this land was also sold?
No.
As per the boundaries.
My lord, if one boundary is taken into consideration, this land can be said to be included in.
And then you execute a subsequent sale deed in which you seem to have indicated that this land is also sold to this person.
No, my lord.
The subsequent sale deed.
That was in favor of IOC. That was in favor of somebody else.
Wherein in those boundaries, you showed this person as the owner of the
He was
subject
my
land.
lawyer, my lord. He was my lawyer who was drafting it.
Then so the lawyer then.
So, my lord,
So far as the issue is concerned, the boundaries settle the issue.
well, I have this to say. If my lord would permit me to say this, the sale deed very clearly says what I sold was the land that was.
Description will not be of any significance
Would my lord
once
permit me?
the boundaries indicate that this land is part of the land sold.
My lord, 59 seconds to develop a case, my lord. All I'm saying is 59 seconds, my lord. Last 59 seconds of this case, if my lord would permit me. What I sold was a property which I received in partition, not what I received in grant. He is my lawyer. He organizes a sale deed in favor of his wife. So the lady who gets it is his wife. The sale deed is drafted by him. I wouldn't know what he has drafted it because I was having a relationship of trust with him. That is very clearly found. My lord would find that at page 47. That raises a red flag, my lord, by itself. That by itself raises a red flag. If my lord sees page 47. And that is not been dealt with by any court, my lord, that's my grievance.
You execute a document, you sign it.
Well, I am alleging.
Get it registered.
Well, I am alleging what palpably borne on record.
That sale deed has not been set aside till date.
Well, sale deed, it has to be only rectified, my lord. If my lord sees page 47 for my satisfaction, my lord.
Yes.
Page 47, this is the order. I am reading somewhere in view of the above fact. If my lord sees that. In view of the above fact, the contention of the claimant that by playing for boundaries have been mentioned by the husband of claimant number 1, as he is also practicing advocate, cannot be accepted as it's an allegation made only against the husband of the claimant. To come up with an admission regarding the boundaries of exhibit P2 and P5 sale deed, which is shown that the court that on based.
So far as this case is concerned, all concurrent findings. But find a good ground in reason to interfere with the influence of
High Court grants me liberty to file a suit. Would my lord
dismissed?
My lord, may I say this? If my lord would permit me. High Court grants me liberty to file a suit. If my lord would say declaration, my lord.
Declaration.
So far as the remaining part of the land is concerned, now 0.8 guntas is gone. So far as the land which is not acquired.
Where is this liberty?
At page 10, my lord. Page 10 and 11, para 22. The entire extent is 2.48 acres.
Measures more than what has been sold under exhibit P2. So other than what you sold also, if the land that has been acquired has been specifically mentioned and the measurement in the sale deed has been specifically P2, if any excess land is available, it is always open for claimant number 2, who is appellant before this court to exhaust the remedy before me. What remedy in relation to what the acquisition?
Because the remaining land which
has already been acquired though.
No, I'm sorry, my lord. The land is a large portion. A portion of it went for acquisition. There is the remaining portion which is there.
Other than what is covered by these boundaries?
Yes.
Liberty granted by the High Court in para 22 of the impugn judgment is, however, reiterate.
Well, the observation should not come in the way.
What observation?
Here he says, I have done nothing because now I am going to allege fraud. If these observations that I did take any steps,
will not allow you to reopen this issue.
Not this issue.
Then there is question of bringing in fraud again.
My suit
We
will
won't
not
say
be.
anything.
Or you withdraw
Sorry,
this.
Mr. Balu.
You withdraw this SLP.
Withdraw.
So High Court, it will revive the High Court order, and you do whatever the High Court has said.
Yes,
no, you can't. You can't just.
No, my lord, I have.
No. Yes, please.
My lord, I am appearing for respondent number 2. Respondent number 1, who is the GPA of all the 7 respondents, he expired. And
Your name also is not tallying. Your respond number?
2, my.
What is your name?
Gurbachan 4.
The name in the SLP is Gurcharan Kaur.
That is that wrongly because respondent number 1.
How do we know? Now there's plenty of money to be taken. People will come out of the woodwork now.
My lord, I have filed application. So far I have not.
But we don't know who you are. Your name is different entirely.
No, that may be wrongly recorded there. It is respondent number 1.
This case has progressed up to the Supreme Court, and you never bothered to get your name corrected.
My lord, respondent number 1 is my husband. He's the GPA of me, my lord. I will say, it is the Gurbachan, my lord, is wrongly recorded. That's what the
You never got your name corrected throughout. At each and every level, your name is shown as Gurcharan, and you do nothing at all. And now suddenly we have this Gurbachan Kaur coming forward and saying, no, my name is actually Gurbachan, not.
No, I will file application.
And I will take the 48 lakhs now.
No, I'm not taking this. It will be distributed among the 7 respondents.
We don't know who's where.
They are coming, my lord. There are some people have died.
Let all of them come forward.
Yes.
Without,
I will
just for the state. You undertook on the last occasion to see whether it was.
Yes, I am in touch with you.
Let's begin find what R2.
But R2 is also a different name lady.
I will correct
We
it.
don't know.
I will file application.
Once the amount involved is this large, people will be willing to change their names also.
I will show all the evidences, my lord. I will show that. It is not that she is living abroad.
You might get married to a Kartar Singh also.
No. Kartar Singh is the GPA of all these persons.
We don't know.
My lord.
Unless you prove your identity.
Yeah, definitely. I will prove.
No question of. What about the others? Two people were abroad. Those people are not traceable.
No.
This lady should be able to take.
I am telling you. Respondent number 3 died. Her sons, 4, 5, and 6 are her sons who are there. They will file application for impeachment.
Let all of them come forward.
Yes, 7 is also died. I am representing all of them in the connected case.
No. One person is not going to represent here. All of them need to come before us. All of them need to face an inquiry as to whether they are who they claim
Yes.
to be. Only then this 48 lakhs will come to you.
Yes, I am not. I know this.
Council, corresponding number 2 states that a joint application would be filed by all the respondents or their surviving legal representatives to claim the amount lying in deposit before this court. Needful in that regard should be done within. How much time would you require for all of them to come forward?
4 weeks.
Within 4 weeks, based on 27th October.
Item number 33.
It's remand.
Your lordship had asked us to file written submissions and posted it for your lordship.
We were under the impression that today perhaps it would be possible to take it up in the afternoon. But unfortunately, my brother has a special bench in the afternoon. So
Lordship may keep it on any day.
better to take it up on a Wednesday or a Thursday. It's anyhow. Admit किया बिना नहीं आएगा. आजकल तो सब आ रहे हैं. Wednesday, Thursday, सब cases आ रहे हैं.
Specially directed. Court directs, then they.
Then it comes directly. On a Wednesday. Just for hearing on nearer date or farther?
Near.
17th.
Item number 34.
34, there's a letter, bereavement. Joint counsel for the petition seeks an adjournment by way of letter on the ground of personal bereavement in the family. On the ground of personal bereavement. Politically. No, 27th October.
35 I'm seeking fast.
35.
Item number 36.
No counter affidavit.
Status filed his counter yesterday.
Just file a counter. We don't have a counter. Our office report also says, office report 30th August says no counter. When did you file it?
Yesterday, I have received yesterday.
31st you filed. Yesterday. Town council for the state of UP.
Yes, yes, first.
State of UP. Today is first. The affidavit was filed on 31/8. However, we do not find. How would you have filed it yesterday? On a Sunday? Sunday?
He filed.
E-filing. E-filing is permitted on Sundays.
Yes.
Portal is open.
Yes, 24 hours.
E-filing. On 31/8. However, you will not find the same on record. Still verified about the same. You need to file a rejoinder.
No,
Not this.
they have everything what I have written.
Based on 13th. Okay.
37.
Please, my lord. We are ready, but the complainant has given us a counter just 2-3 days ago. And I believe the state has filed nothing.
Services awaited is what the office report.
I have paid for the state, I am for 1 and 2.
Who is to be served?
We had half a mind not to seek rejoinder, but I don't know, I'll filing a counter. I'll be filing a counter. File it in advance because they've taken time twice.
I don't know why everything said is awaited.
But you took action against the alleged infringement of trademark.
Completely civil action.
No, there is.
No, 2022 you took action. In the year 2022, you took action against them. For what? For
These notices were sent.
So,
However,
what does it mean?
No, Muloj, there is criminality involved. I'll explain.
You can make anything.
No. It's criminal. In fact, they
lost the Competition Commission also.
Muloj, that is separate.
The Competition Commission holds that there is no evidence that they used your information at all.
Now they are misleading the investigation by relying on some patent which has been abandoned.
How will the police inquire?
I'll satisfy. Let the investigation complete. I'll satisfy.
No investigation. I mean, you make MD of a multinational company as one of the then you drag them to
this requires
patent IP matter.
This requires consideration.
No, the case for
This requires consideration. Lordship is giving a
separate IP matter.
My senior is there. My Lordship may pass over the matter. If Lordship is going to hear the argument.
also.
Item number 38.
Lordship,
In this matter.
Lordship, this is a covered matter.
R1 is still not served. We can't allow the matter the absence of the other side.
My lord can't permit me to serve that.
R1 needs to be served.
My lord, I have served, but might have not been. My lord, kindly give me another opportunity to I will serve them.
Service of notice awaited. As per the office report dated 29/8/2025, let's start the service of notice.
Item number 39.
Your Lordship, we have filed the PF.
R1 and 2 are unserved.
Your Lordship, kindly allow me to publish through the publication
You
because
need
he
to
is
file
the
an application for that.
he is the
So the office report dated
he is the
29/8/25, respondent numbers 1 and 2 still remain unserved. Learned Council shall take all necessary steps to complete service. Matter may be listed before the Learned Chamber Judge or Registrar's Court, before the Registrar's Court for completion of this process. This thereafter.
Number 40.
They have a pairing in item 40. So for the 40.1 and 40.2 is concerned, I am not a pairing.
These matters need to be heard.
Lord, 40 is completely different.
No, but it's been clubbed with.
It has been, Lord, the rest of this constitutional validity. 40 is just this, my Lord. The petitioner made a submission before the single judge.
Single plot layout you want.
Lord, if your Lordship sees page 95, single judge's order, they made a submission before the single judge saying, please pass an order to this effect, and then we will consider. The single
40 and for the petition, I will make my submission.
Lord, this is all that is. I'm only trying to say, my Lord, single judge submission was made, single judge agreed with the petitioner.
What is the single layout plan?
Lord, Lord, there was a larger.
According to the journal plan, Lord, like because if it falls within the residential area, then in case you are asking for commercial, then
Lord, there are two smaller plots.
What you have to change.
They'll make a layout within the layout.
Within the layout.
Lord, the two plots together are considered a layout.
Zonal rules are there.
And that has been the petitioner.
We'll have to hear this matter.
Lord, it is completely different to the others.
No, once it's tagged, we don't need
matter is
that.
appeal.
Unless you're able to demonstrate that the very tagging is
yes, I would be able to say that.
No, but perhaps the amendment, all these amendments which have been upheld by the High Court,
Lord, even if everything,
which is the subject matter of 40.1 and
those are the amendments. Mine has nothing to do with this.
these amendments have nothing to do with this layout approval.
Nothing at all.
It's got
Not only my.
The Town and Country Planning Amendment Act,
The act alone is
happened
the same.
was,
all these are.
when Commercial had constructed the Shadi Hall without taking any approvals.
No,
Not without even converting it to non-residential. purpose.
What has happened there?
Thereafter, Mullah, they said you give post facto. I said, in my act doesn't permit you to give post
That is-
facto.
that is-
Now he is running a marriage hall there.
No, that is.
There is a stay, my lord.
Look,
There's a
that's
stay.
He has constructed it, my lord,
No,
without
stay
any
of what?
stay of running the.
Oh, I see. So it's not running.
So
it.
that was granted
So
by
that
the-
is the urgency on your.
No, the urgency is this, my lord.
You've already completed the construction without approval. Now you
No,
want to
no,
start
not-
running it.
Every approval has been obtained, penalties have been imposed, my lord.
You changed the
No,
land use.
what happened is only this, my lord.
Did you get the approval for the change of land?
Everything obtained.
Post facto, post facto.
Show us where is the change of land?
But if your lordship sees page number R5, counter page number 52, there it has been paragraph number 5 deemed approval. If your lordship, no, I.
Page
Deemed
Deemed approval.
Deemed approval is different.
Lord, if you, I beg your pardon.
Deemed approval for change of land use?
No, I'm sorry, that's the wrong page. If your lordship sees R1, page number
For
12.
change of land use, I'm sure there's no deeming. clause.
Not even, only for.
Lord, I'm coming to the by stages, Lord, if your lord.
Prior to construction.
I'm sorry, I'm answering my lord's question. If your lordship says R1, counter, page number 12. This is the government's permission for change in land use, which your lordship.
Page number?
Page number 12, exhibit R1 attached to the counter.
What counter? We don't have a counter here.
What that is?
It's there?
On in, I mean,
Inside?
file it is there.
Oh, yeah, I don't have a counter.
There is a counter.
What is the document he's looking?
There is a counter affidavit to the SLP. And that is filed on 16 October.
This is your application.
Yes.
Where is the approval?
Lord, R1 is the recommendation by the government at page
So where is
12.
the approval?
Lord, that is the recommendation given by the page number 13 with regard to the approval so concerning.
Recommendation, after that,
Lord, after that.
has the recommendation been acted upon?
Yes, it has been recommendation acted upon.
Where?
If your lordship sees page number 18, is the petitioner has granted approval and he says pay this fees and the change approval is granted. It's the petitioner's conduct.
Change of
Page number 18.
extension to commercial.
And this is a very petitioner.
To deposit the amount,
Yes.
not that there is an approval there.
Yes.
Thereafter, what did you do?
No, thereafter I deposit the amount and the government order has been passed, my lord. That is at page number P10 of the petitioner, SLP.
Page?
Exhibit P10 at page 106. 101 is the starting page. And then 106 is the approval. Government order is at 106. May I read this government order dated so and so. And in the background of points described in the introduction, your lordship has it. As per section 14.8, Karnataka so and so government has given its approval to the proposal for change in land usage of the remaining land so and so.
This is the same land, madam?
Yes, only one land.
Is it, no, is it the
Yes,
same
I'll
land?
just point out, Lord, let him.
I don't
Yes.
understand if I'm asking you, is it the
Yes,
same
sir,
land?
it's the
Answer
same
can be
land.
yes or
Same
no.
land? Change of land use then.
Yes.
Then what
But
is
we-
that? Is the
There are 3 steps which they have to take before they start their construction. First is under the Land Revenue Act, they have to get it converted from residential to non-residential purpose, which comes under Land Revenue Act and under section 95 and 95(4) permits post facto approvals. Now, thereafter, the second step is they have to come to the planning authority. They have to ask for land use because in the zonal plan, it is partly residential, partly commercial. He wants to use it for commercial. There has to be change of the zonal this thing that therefore that is the second stage. Then comes building approvals from the corporation. No, he did not obtain any of them. So far as the first step is concerned, he did post facto approvals because their act provided for it. But so far as Karnataka Town and Country Planning Act is concerned, it does not provide for post-facto approvals. No? So that's
What approval does he have to get from the,
for the land, change of land use for, from.
under the town and
commercial to-
country plan?
Yeah, residential to commercial and this thing. And
What about this
land.
government order? This is
As
under
far
which
as the
enactment?
government order is concerned, it was subject to the outcome of the court.
No, this is under which enactment? Then? It's not under the town and country plan.
Look, so far this is concerned, my lord, this was passed under the, by the state of Karnataka, my lord, recommended. For,
It's
because at
under
that
which-
point of time, writ petition order was passed, writ
No, but-
appeal was pending.
Under which enactment is the government permitting this change of land use?
So may I explain in a nutshell what happened, Lord?
This is under the.
It was originally.
The Urban and Rural
This is-
Planning Act 1961.
That is the town and country planning at page 104, your lordship will find it.
Your order starts with this
104, your lordship
sentence.
will find it.
So, where do you find it?
This page
So
106.
what happened here is the municipality
What
out
your lordship will find it, my lord?
Background.
Lord, the
We'll give you a
municipality.
date now, Mr.
If I may request one, I have filed two implement applications.
You are for whom, Mr. Modia?
I'm for the implementing applicant. The application is filed because
they?
they are landowners
In 40.1.
40.1 because I'm directly affected by the decision in this matter.
Lord, I appear for the state in 40.1 and 40.2. May I just?
We don't
request
have
that
any
fix the
implement
date?
application.
It's IA number 237
Oh, I see. 37858.
and IA number 16838.
Both, in both your
I am
applications.
appearing.
These two applications for intervention and treatment are allowed. You need to file any counters?
I'll file not required, Manoj. I'm supporting.
I had a request if this matter can be detached. The issue as far
No,
as Bangalore
the order passed in the
No, no,
first
not that.
matter specifically mentions these two other entities.
There's
The
Gulbarga.
preamble to the government order says that not.
Anyhow, the title, no, the body of the order, these SLPs
Lord,
are
the
mentioned.
order starts at 100.
Your order mentions these two SLPs.
No, that is the
And it
preamble.
says subject to these two SLPs.
There's
May
one
I
more
request
request.
a date for the entire batch. My lord, I appear
List
for the
for
state.
hearing on. You will have to wait because you'll have to join the queue. We have only one NMD.
There's one IA which
My
is
lord.
filed by the state.
Otherwise, we'll grant you leave and.
My lord,
It is already granted. It is already granted.
Lord, it has
It is
to be.
already there. Oh, then
May
leave
fix
granted
it on
in.
regular date.
It
Yes,
just,
of course.
Lord, my submission is it can
And
be.
the matter is tagged with civil, leave granted. Tagged with civil appeal number 767-768 in terms of the earlier order. List for hearing on 15th October.
I'm deeply
Grateful,
obliged.
grateful.
41 along with 55.
Grateful.
Please, my lord, 41 is connected with the 55, my lord. In 55, the counter has not been filed. In 41, the counter has been filed, my lord.
Counter has been filed in 41.
But 55, my lord, they are connected matters.
Both matters counter has been.
55 also. All the points also. 55 is not one item.
It's right put
55, 55. Point 1, point 2 is also part of this batch. It is not tagged with 29. That's a mistake. So all these will go together. You need to file your counters in each matter. If you wish to pay you are appearing for the respondent.
Only for respondent 40.
The respondents are different in all the cases. So it is only last week the notice has been
So
issued.
if you are willing to pay the amount with the reduced interest rate.
So there are two things that I want to point out also. First thing, Lordship, they are saying that they are willing to pay the interest on principal amount. Also, they have tripartite agreement, as per which the 22 lakhs was paid directly by the bank to the builder, and 5 lakhs was paid by me to the bank. That point.
Why would you pay to the bank?
Also, on the loan amount, Lordship. The loan that
in repayment of the loan, you pay 5 lakhs.
Please, Lordship, that aspect is not considered during the issuance of notice, Lordship. That should be considered, Lordship. 5 lakhs was paid in.
But it's better that all of you sit together across the table and negotiate whether you would be willing to accept the interest
If I say so, my lord, if my friend is complete, then I have, my lord, it's not correct what my friend is putting the case. Is actually, my lord, if we see that.
You are now saying that you're willing to refund the amount, but at the interest rate, which is.
Yes, my lord, what High Court has done has directed to
try to mediate, negotiate it.
My lord, we can, my lord may direct that.
So we'll refer the matter to mediation. You undertake the mediation with all of them. 55, who is appearing?
My lord, the notice has been issued only last week. There's no one is appearing, my lord.
Complete also. So this perhaps is not complete. 55. Waited. Then we'll just give you a date. Let all of them come here after.
Pleasure.
As per the office report, service is awaited. Proof of service is awaited in item number so. Registry is directed to complete the process of service and this the matter thereafter. We can't give you a date without this the matter. Don't say thereafter, give a date. This the matter on 24th November.
Pleasure.
Much obliged.
Item number 42.
Letter is there. Letter. What is the personal difficulty though?
She is not.
No, then.
They circulated it for residents.
But normally. The personal difficulty.
She is not present in Delhi.
Not present in Delhi. Why? Holiday.
I do not know. I do not.
This personal difficulty will not do. You have to give the actual reason as to what constitutes this personal difficulty. We are not going to accept this. We've already asked the registrar also not to accept such letters which merely say personal difficulty. The other day it didn't say difficulty also. Reason personal. So we don't know what that means.
Some good.
Counsel for the petitioner.
There's a problem when the mics are on.
On the ground of personal difficulty. List on 1st December.
Obliged.
Item number 43.
Item 43, services complete on all written.
Counter affidavit is not filed.
Yes, Manoj. This is coming first time after notice, Manoj.
Do one time?
My lords.
Then Council for the state.
Yes, my
For
lords.
the state of Himachal Pradesh. So respondents 2 and 3 are also state authorities.
Yes, my lords.
Very well. For the state, for the respondents, seek some time to file a counter affidavit.
My lords, they have private respondents as well.
Private respondents. State authorities seek some time to file a counter affidavit. You also want time, and Council appearing for the private respondents also makes the same request. Needful in that regard shall be done within 3 weeks.
My lords, I appear for few of the respondents.
Yes,
Lords, it may be 4 weeks.
I appear for few of the respondents, my lords.
4 weeks. They joined the data training will be filed within 2 weeks thereafter. List on 17th November.
Item number 44.
44 happy for the.
Yes.
I'm seeing time to file a counter.
44 law and council for the respondents.
I appear for both. I appear for both. Both are original.
Respondents seek some time to file a counter affidavit. Needful in that regard shall be done within 2 weeks. 2 weeks?
2 weeks.
Joined at the training may be filed within 27th.
Number 45.
Appear for the state.
Your Lordship, I appear for respondent number 4. I'm seeking a passover. I'm being led by senior.
But your counters don't seem to refer to these photographs which
At
are
all,
filed.
that's right. Plus, we went and requested them to, because first with your last order, we went and said, why don't you do an inspection today? Because that inspection was done in September 2022, report of 23, cancellation of transfer in 2024. So we said much water.
Photographs which are filed. There's no mention of it in your, you've only gone by the earlier inspection.
That's right. That's right. We can conduct.
If they've already constructed a regular Pakka building, and the students are still with you, or
No, but they have absorbed somewhere else. No students.
But
there are no students.
No students.
There are no students.
I may just point out, before the High Court, they obtain an interim relief saying that students are studying. 2 months later, they write a letter saying all 200 students have been absorbed in some other.
Because once you cancel my transfer, there is no question of me taking students there. That's R4. R4 is R4 is another competing school.
They seem to have conducted classes in this constructed building. So by the time you actually passed these orders, they had already constructed the building.
At the time the order was passed, the school which was operating was a tin shed structure. Not even and that's what the education officer in his report had indicated.
Because the education officer's report is of 2022.
Your Lordship, if I may point out.
Because the education officer's report is of 2022. What stops them from inspecting the school today? We are a minority Buddhist.
I'm not saying there should not be another inspection. I'm not
Minority Buddhist school. Why don't you undertake an inspection?
Very well, we'll come back.
Your Lordship,
We'll grant us 4 weeks.
Your Lordship, in my counter at page number 11, I appear for respondent number 4. I have already attached the details of students who are admitted. There are 0 students, Your Lordship.
As on date.
As on date.
They're admitting them. Once they have no permission, then where is the question?
Ask them how many studies they run.
But now they've got the infrastructure ready. Why should it be wasted? If there are students who are in a proximate area, they can at least come to this school rather than being sent to a long, faraway school. Is it not? Land Council for the state undertakes to inspect, shall undertake, sorry, don't say the Land Council for the state. The state of Maharashtra shall undertake a fresh inspection of the petitioner's building and infrastructure and file a report. Based on what time?
4 weeks.
7th, 6th of October.
Great.
Item number 46.
Jesus. Lordships.
No counter after this.
Well, we had served them on 23rd and again on 25th because the council said she was not even a copy.
Your Lordships, I'm seeking some time to file the.
Only for respond number 6.
Yes.
Who's respond number 6?
Gamada.
That's 5 actually.
Yes, for the state, 1 to 4 minutes, I take time, 1 to 5.
State government.
Please.
You want time?
Yes.
Plus my learned friend on the last date indicated.
For respondent numbers 1 to 5 and the learned council appearing for the respondent number 6 authority. Take some time to file the counter arguments. We will in that regard shall be done within.
Plus my IA is there. They're taking coercive action.
We've already said status quo.
Plus, despite that, plus that's why I filed an IA on unrelated projects. Because they are citing there is no stay on demand notice. They will not even let me.
Allow me to file my reply, my lords, and argument.
But once the order of status quo is there, what
Please
is
see
this?
close my IA.
The order, the status quo is with respect to the land.
Already status quo is a very vague order, so we'll clarify it today. What is this? Respect your
But for unrelated projects, my other projects, they say we will not accept your payment for extension of time because you have not paid demand.
Going to date with training will be filed within 1 week. Earlier status quo order shall continue to operate till the next date of hearing. We further clarify that respondent authority shall not stall any process initiated by the petitioner on the ground that the demand notice, which is the subject matter of this litigation, has not been complied with.
Grateful.
It's from third one.
Grateful.
47.
47 responding
47.1
was not complete.
47.1 there's an IA to join the party. Last order says somebody is to join this party. Let that IA be permitted, allowed. So that's why
2-3 housekeeping orders I need, my lord, so that the matter can proceed on the next date.
it's a second matter.
Well, it's item 47, if I can close 47 first. Well, last time my lord had recorded a statement that service affidavit of service has been filed for the unserved respondents. However, my lord, those packets thereafter remained incomplete and they came back. So we are requesting for the paper publication, that is IA number 18804 of 2025.
IA number
18804, my lord.
Not listed today.
My lord, it's there today, my lord. The office report also notes that it's attached to the file of the court.
There's a second volume, is it? There's no office report here.
But in first matter for a contesting party, we have filed a reply. I am the contesting
I will
party.
file a rejoinder.
Raise the state authorities.
One by one, we'll clear all of them.
IA number 18804. Substituted service of the notice from responding numbers 3, 4, and 5 is permitted by way of through paper, through publication of the said notice in free. Where have you come up with these newspapers? Everybody read them.
Malad, these are
We found the cheapest papers. Is it?
Malad, People's Journal and Navshakti, Malad, in Mumbai and Thane, they are the most.
Your lordship may say Times of India or something. I think that would be better.
In Times of India,
Add to the expenses.
English newspaper, and Navshakti is a popular paper. Navshakti, Marathi newspaper having circulation in the state of Maharashtra. Proof of such publication shall be filed before the next date of hearing. Then, 47.1, R1, 2, and 6 are services awaited.
Malad, we got a dusty notice on 28th of August. We have attempted service. I'll be filing my affidavit as soon as I receive a
We'll go by the office report. As per the office report, respond numbers 1, 2, and 6 still remain unserved. Steps shall be taken for completing service.
Today, one more I taken out by them.
Which one is that?
196631. Last time court had directed them to join the party. Therefore, joining the party, let me be permitted.
In fact, your lordships have said we should join the cooperative housing society, so we filed that.
IA number 196631. This improvement application is ordered and the so and so society is brought on record as respond number 7. The respondent is gone to plan to file its counter affidavit.
But they are not reported, they will not be served.
Oh, I see, you're not appearing.
Not yet.
So it's service.
Not yet. I will.
Issue notice to the proposed respondent, returnable on the same date. Service shall be effected by all means including the state. Yes, from 10th November.
Please.
Item number 48.
48.
Still part of the OSR, and it was constructed, my lord, by the residents there.
The land was gifted
Yes.
Lord, I'm
by
extremely
way of a registered gift deed.
Lord, I'm extremely sorry. In the previous matter, the stay still today, your lordship has maintained. I'm very sorry. I'm
You to operate till the next.
I'm very. The stay is only in the post matter. Yeah, only in the first matter. Only in the first. No, it's only in the first matter.
Mention that. Yes, Mr. Giri.
Yes, the registered gift deed, my lord, takes place.
Who is appearing for the response?
My lord,
Have you filed a counter?
No, my lord.
Do you need wish to file
I
it?
want show no judgment, my lord. Last appearance.
You've already showed it to us last time. Justice Arun Mishra.
Yes, sir.
Share it with the other side.
Let them file a complaint. They want to, subject to your lordship.
But once the
My lord, please look at it, my lord.
There is a
108
question.
apartments.
It's supposed to be an open space. It's already executed by way of a registered.
That's correct,
gift
my lord.
deed. It is given to the authority.
My lord, statutory definition.
You take over and build a temple.
No, nothing, my lord. It is not that, my lord. The open space itself is for the benefit of the.
So how much
residents
open
there.
space are you willing to surrender from?
It has been
what you
done.
already have?
The whole thing, my lord, this.
You've
only
taken over
120
the open space.
No. Only 120th. It's
Whatever
still
it
a
is,
space area.
whatever you have taken,
Yes.
how much are you willing to concede? Double that amount. Double that amount you give them then. From
Give
your
to the corporation, my lord.
to the corporation. They are supposed to keep
But
this as open space.
I'll find out, my lord. It still is an open space.
You can't take
It is
law
still-
into your own hand.
But it was
and
not
go,
done that way.
I'm building a religious structure, so nobody
No,
can touch it up.
my lord, it was not done that
That
way.
has perhaps stopped now. I remember earlier, Mr. Giri, temples would be built in the middle of the road. And
But
then,
I've
and then
seen that.
everybody, the court also says.
Hands off. Nothing could be done. Your lordships are right. That cannot be
We have,
permitted.
I think, gone beyond
We
that.
have gone beyond.
You
My lord, I
can't build a temple on a road and
No, I
say,
understand.
now I built a temple, therefore nobody can touch it.
No, my lord, what fell from your lordships, my lord? Please give me some time.
You concede
Let me also-
double the extent of land that you have taken.
Extent of land, my lord.
Double the extent of open space which you have occupied for this temple construction, you will give it to the authorities.
Only
You
5
can't,
cents.
you can't do this
Only
kind
5
of.
cents.
No, double it.
My
Double
lord,
it.
I'll do that. But not, lordships may not say double now. Lordships may give me time to get instructions.
Petitioner seeks some time to get instructions as to whether the petitioner would be willing to concede and the extent to which it would be willing to concede open space in lieu of the open space occupied by it for the construction of the temple in question placed on 13th October.
Wait.
Counter.
Just take 1 second. Your lordships have asked me to do it. I'll get instructions. Please look at the locus of the person who moves the High Court also.
And you've also not heard.
No, I was not heard. No, my lord, what is he going to do with it? He is not a resident. He is not nowhere near.
Who is he?
He is an outsider. It's styled as a public interest litigation. He himself says he has nothing to do with this.
But still, what you did is
No,
illegal.
no, my lord, my lord, illegal if your lordships go by the fact that if open space reservation.
Someone brings an illegality to the notice of the court.
It could
Bound
be.
to act upon it.
It
We
could
are not
be,
going
my lord,
to. We are not going to sustain an illegality on the ground that
No,
someone
it
who
could-
had no.
your lordships will not give
locus
us.
brought that
Your lordships are right. Your lordships are right. But at some point of time, my lord, the court should have also felt that let them file a counter, let the corporation make it stand clear, and then take it. They take a
What
decision
about
on
the
this.
residents of that locality?
Nobody, my lord, nobody. It's within the premises, my lord. There is a compound. It comes within the premises.
Because you have sufficient number of friends in that local.
No,
authority.
my lord.
You thought we'll get away with this.
No, my lord, but then,
Obviously.
no, my lord, it may not be a one-to-one affair, my lord, between the association and the person concerned. He is nowhere near. society, some people also complain to the corporation. Let it be.
You're for the corporation.
No.
You're for the complaint.
He's for the complaint.
Who is for the society, for the corporation? Corporation, someone is appealing.
They have been served.
Obviously, you have enough friends.
No, my lord, see.
Then obviously, they're not even coming forward.
Not that popular. It's an association of persons, my lord, who are peace loving.
Meanwhile, you find out that is.
I'll find out, my lord, but let the corporation also come appeal, file a counter.
Tell them then.
No.
With your contact, you can tell them to put in an.
No, my lord. Anyway, my lord, let him also file a counter. Let him say what
Counter
he has.
may be filed by the respondent complainant by the next date of sheriff.
49.
Great.
I was granted anticipatory bail in August of 2015.
No, the issue is only a passport. I think you have to deposit it.
It's already right.
But now you've been given liberty to seek modification. The lady fears that you will take the passport and fly.
May I say something? First of all, the application.
It has been filed. Investigation of charge sheet has been filed. There is a prima facie case against him.
No, but unfortunately, liberty was given. Has any application been filed before the trial court?
May I just update you? There are three orders. Let me just indicate. 24th of August 2015, your lordship granted me anticipatory bail, told me I must deposit my passport during the investigation, and that is the position. After that, two orders were passed. First on 5th of February 2016, where I was told that the condition stands modified, and if I have to move out of Chandigarh, I should take the permission of the trial court. After that, your lordships on 1st of September 2017 granted me liberty that if any modification, go there. From 2015 till now, charge sheet filed, first supplementary charge sheet filed, second supplementary charge sheet.
Are you trying to get hold of your passport?
I have moved an application. The two things have happened. The learned trial court says because this MA is now pending here, I am not going to pass an order subject to what your lordship's clarification will be. The prosecutrix moves an application here on 6th of September 24. For 1 year, that application has not seen the light of day. It still lies in defects. There is no.
You are a citizen.
No, there is no application today.
The moment you get your passport,
You will
we
fly.
will not be. I mean, there's government of it. I mean, the prosecuting agency will not be.
Because I asked myself today, your lordships do not even have an application before your lordship's board. There is
an application.
There is an MA.
There is not. The MA is in defects. It has not even been supplied.
For modification of that particular line, that the passport will be with them till investigation.
I asked.
Says no, not till investigation. Till the trial.
And I asked myself, surely that application needs to be registered after
Right
20
now, you
of
are not
defense.
leaving the country, to be very frank.
Because may I say this, today I don't even have an application. The application is, the defects have not been cured. The application does not stand registered, and your lordships are called upon to actually pass orders on that application. I don't even have a copy.
MA diary number.
Please see the chamber orders passed week after week for 1 year.
There are no other defects. It's only because the person is seeking permission to file this miscellaneous application.
I have not.
There are no other defects.
I have not even been provided a copy of that application.
Well, the defect
For 9 years, I have stayed here.
It has been weeded out since the.
And it's not as if it is not as if citizens.
The defect is she has not filed an application to appear and argue in person, nor has she provided paper books of the SLP. That's all.
Well, that's right. Well, I need that application with reference to making my submissions on it.
You make your application. But in the meanwhile, we are not going to allow the passport.
The application of by the trial court stands rejected as on date. Subject, that's right, subject to your lordship's orders. So there is absolutely nothing.
The condition was imposed because it was felt that probably he might be exonerated after the investigation is over.
That
Now there's a charge sheet, it's been fixed, there's a FSL report against him, there's a DNA test against him. Now conditions have changed for the worse, if we can't be given the passport.
Then comes.
Well, we can go into merits. I have eyewitnesses that they've relied upon in my favor. So we can, at the end,
Don't leave the country.
so that your lordship anyways.
The miscellaneous application not being served upon. Please serve a copy of the MA upon the senior counsel.
It was his application for
response to the application may be filed by the next date of hearing. In the meanwhile, we make it clear that the trial court shall not pass any order to the effect that the passport of the petitioner in the special petition can be.
So that orders, I'm so sorry, the order's been passed that there is, that the trial court says, I will not pass.
It's better that we say it so that the.
As your lordship, otherwise the trial court has already said that. That order's been passed.
Will not be released to the petitioner in the special petition.
Thanks.
This order will at least remain operative.
Even discharge has been dismissed, my lord.
Discharge has
The charges are framed, I undertaking a trial. For 10
of giving you back your passport.
It's for 10 years. For
You're an American citizen, you will fly where is it?
Your lordships have also consistently said it's not as if citizens abroad cannot be put to terms for their travel. For 10 years, a man has been in the country with no travel.
My lords may expedite the trial. Let the trial be.
So today I asked myself, your lordships have to balance
Not
those.
a citizen of this country, where is the question?
Because I am
People
who have already gone there. There are so many.
Because all, and I'll file my responses and I can, we do it.
With the US,
We do.
no extradition.
There is an extradition treaty, many people have, but that's not a
It's very difficult to get them back.
That's not a circumstance.
I think the US
My shoulders are not big enough for all the others who have gone and not come back. Surely, because I will not pay the price of every
They will
person.
become your role models.
Because I am a person who has complied with every single condition for the last 10 years and place it on record. But for kindly,
Go to conclude the trial at an early date.
I'll place my reply. I'll place my reply.
Now, you file your
I'll place my reply.
Just on 3rd November.
I'm okay.
My lords, item 50 and 50.1, my lords had directed on the last date that
These matters have to be heard. We give you a Wednesday.
Not today.
Not today. May not be possible today. With my brothers in a special bench in the afternoon, we won't do it. List for hearing on 12th November. Current counsel for the parties are at liberty to file short written submissions not exceeding 2 pages.
much of it.
For 51.
51.
51.
The meeting.
Some settlement. You
No,
will settle
it is not possible.
Not possible.
It's not possible. We will have to trouble your lordship. Can it be on some date convenient to your lordship?
A 20-year-old scheme, my lord. We are being deprived.
Why is it kept at diary stage still?
Because there was delay.
Delay fine.
No, delay, notice is also issued.
But delay is not being condoned by the legislature. Delay condoned. This matter will have to be heard finally. We'll grant leave then.
No, the reply is on record, everything is on record.
No, but if you keep it at this stage, we have 1 single day per week. Which means you'll join the queue in all probability. It will take a year for the matter to reach.
Not,
If we grant leave Wednesdays and Thursdays, hopefully you'll stand.
Your lordship, your lordship is quite sure it will finish quickly. But this is
Even on Wednesdays and Thursdays, you will have to join the queue. It's not that you get any priority there.
Complete in this matter, even at the last time we said the settlement is not possible. We have very strong case on law.
Not we, you say it. Rest of
R50. Yeah. I am.
We granted this for hearing on 15th October.
Please.
Item number 15.
Great please, your lordships. There are two important factors here. One is the Sushila.
We were granted interim
3 years.
anticipatory bail.
We were granted for 3 years. My lords, Sushila Agarwal says that you are granted in the normal course till the end of the trial. But that was overlooked.
Once you don't appear after securing this interim bail,
tried
your bona fides are,
Your
bona fides are clearly suspect.
May I then suggest?
And it's a public scheme and you.
But I have not been named except by the person who filed the complaint.
But this abuse of the earlier relief granted to you.
I appreciate. My lords, may I then request this? The lordship give me 2 weeks to surrender, my lords, and the matter be taken up on regular bail then.
We find no good ground and reason to interfere with the impugned judgment passed by the High Court. However, if the petitioner surrenders within 2 weeks and applies for regular bail, his application may be considered on its own merits and in accordance with law expeditiously.
And deeply obliged.
Please.
53.
May I please, Lord?
You keep 2.74 crores pending to recover 17,57,480.
Lords,
Is he not entitled to interest, madam?
Lords, in fact, it is only after the inquiry, my Lords.
Whatever it is, but you keep this amount with you. And finally, your finding is out of the 2 crore 74 lakh, sorry, 2 crore 74 lakh, you need to only withhold 17 lakhs and all. So why should you get the benefit of this withholding?
Because it was an inquiry, my Lords.
That doesn't mean that you keep the entire amount. You kept the entire amount, so he's entitled to interest on that amount. That is what the High Court said. Sorry.
You
find no good ground in reason to interfere with the impugned judgment.
The principal amount has
No.
already been paid, my Lords.
Especially petitions accordingly
We
discussed.
just get some time to pay the interest.
Nothing.
State is asking.
State.
Obliged.
May please, your lordship.
All three.
The plaintiff is the pujari of the land who filed a suit for eviction for his own personal bona fide requirement, your lordship.
This is a Balaji temple.
Yes, your lordship.
Not some sect kind of temple which is private.
No, your lordship. It is a Balaji temple, your lordship. Now they have been living in the premises for now 69 years.
Who manages the temple? This Purohit is the whole and soul, is it?
The Purohit died, my lords. Now he's one of the heirs of the state.
There's no governmental control over this temple. They have the Charitable and Hindu Religious Endowments Act.
Yes, your lordship. They have not implemented the deity as a party, my lords. In fact.
And the Purohit is now dealing with the
Yes, your
temple property as his own.
Even he has sold some of the part of the land also, your lordship. It belonged to the temple.
But the government has no control over these kind of temples.
No.
Which state?
That is your lordship. There's a public.
There must be an act.
There is an act, your lordship.
Then the government authorities are not involved there.
No,
They
your
don't know about this temple maybe. You should notice, you should notice returnable on 27th October.
My lords, I'm requesting to stay.
The service shall be effected by ordinance including death. In the meanwhile, there should be stay of the operation of the impugned judgment.
I'm ready to.
See, you are really lucky. Because I was persuading my brother to dismiss it.
But
And
you
when
have
one
a
person
point.
says notice and stay, it has to be.
You have a
stayed.
point in saying that the Purohit seems to be grabbing the temple property and treating it like his own. So you get the benefit of at least that question being looked into.
I'm ready, my lords.
My lord, this was filed earlier, my lord.
We've already granted an order.
Yes.
You're covered by that.
Your lordship may thank me for that.
Why should
Your
we
lordship may
multiply
thank-
the number
because
of
there
cases?
are-
This
there are-
court hall is not as big as the court hall number 1. Court hall number 1 itself was unable to take the crowd on in the last round of litigation. This court hall can't sustain it at all. So there's no point in multiplying the number of cases. The issue is the same. We are already looking into it. Why should we entertain more number of cases?
Your lordship may see just impugned order. My lord may see impugned order.
Whatever the impugned order
Yes,
is,
sir.
we have already
Your lordship
tagged
may-
all the issues in the order which we have
Go
passed.
through this SLP.
So far as tainted candidates appearing is concerned, we've already said everybody is entitled to bring it to the notice of the Service Commission's Council as to whether any tainted candidate is appearing.
There were two issues, my lord, when I went to the.
This 45-50%.
That is taken care of. That is taken care of.
You can't
by
object to
SLP.
it.
Yes.
To that policy decision being applied to others.
Yes,
In fact, it will help you because you get away with 45, they have to pass the 50.
My lord, I am covered by that order that your lordship has
Well,
passed.
we
in
don't really
SLP
see the need to multiply the number of
46049. The other issue is, my lord, serious issue is that in 2016 rules, there was certain mechanism
to evaluate the candidate by giving marks of 10th, 12th, etc. weightage in finalizing the list.
That we have not said anything in
Why not
the
make-
earlier judgment. We did not say that the process will be the
Because
same.
the High Court
We
said,
did not say only this number of candidates will be permitted. So you are all trying to read something more into our
the
judgment.
problem
than was
is, my
said.
lord, now that condition has been removed.
That is not
Now
the
only
benefit of
PG and
the-
graduation, my lord. So that, you know, may at least tag it with this
No.
SLP 46049.
We are not going to entertain any more matters, as we have already entertained sufficient number of cases and all issues are already identified wherein we find no grounds to entertain some more cases on the same issue, especially petitions according to this piece.
I just wanted to apprise my lords, we've published the list of tainted candidates, we've also cancelled the admit cards of all those.
All those.
We've done that.
There are serious issues with that list. I have a list which I am not passing on to my lord. There are many tainted candidates who are missing from that published list. So that is another.
Get the list from?
Because earlier they had given the number, roll number, etc. So that number is missing from the published list that they have produced.
That is why we have given liberty to you also.
That's there, my lord. So that's why I am not. It was not necessary to be pointed out right now because that is, according to me, that is not a perfect list.
Please verify all that.
That's why, my lord. That's why, my lord. This I was making submission, my lord. Your lordship may tag this, my lord. Instead of dismissing, my lord, there is one more petition pending. The one more will be there. This is essentially
only this one. The writ petition we are not entertaining. Whoever is appearing in this.
46049. SLP 460.
Issue notice and tag with so and so.
SLP 46049.
Only this one matter will, because this issue perhaps
But may I just clarify that, my lord, the CBI list had more number of people, but a lot of them were not appointed. So therefore, our list is an exhaustive list of those
those
who were
who-
appointed and have been removed pursuant to this code.
No, but even those who are not appointed, if they are shown as the tainted candidates, you should not be allowing them to appear.
No, we won't allow them, but the
No, but according to the
list
senior counsel.
my lord's direction was that we have to publish the list of tainted candidates who were appointed and who were removed. So this list is only dealing with those candidates, that's fine.
But remove the other tainted candidates.
I'm difficult.
And then-
Item number 57.
Wait, please. 57.
Yes, wait, please. Alert.
If this person has been teaching, be it under one title or another, since 2004.
Yes.
And you want to deny him the benefit of 10 years of extra service.
No.
2004 to 2025 he teaches.
Alert, what has happened?
And now you want to get rid of him.
No, it's not just
in our country, Mr. Joydeep. The very unfortunate situation is that we don't respect our teachers.
No, this
in all other countries I have been to, I find that teachers are exalted.
Bow down.
But we,
This is not a single person.
We look down on the teaching profession as some sort of do away with profession.
Just give me a minute.
Them, abuse them, exploit them to the greatest extent possible, and then get rid of them whenever they get a little too heavy on our purse strings.
No, this is not that situation. There is
exactly that.
This is not one person, first of all. There is a whole
2004, 21 years this man has taught.
No, it's not that. Just give me 1 minute.
But why do you have these different nomenclatures? They're all teaching.
No.
You have Shiksha Mitra, education volunteers. What else? Whole lot of names you come up with.
None of these people, Lord, are regular teachers. They have not come in.
Why do you have these distinctions to begin with if you are using their services?
If I may just explain in
Why
a minute.
do you do that?
Please just give me a minute. Before the RTE, my lord, came in, these people, this kind of services were there. Then this particular, my lord, group, Shiksha Mitra, are people who are not teaching in schools. They are teaching outside schools.
They are still teaching?
No, my lord. What
they are teaching children?
They cannot. I'm telling you, Lordship, my lord, just give me a minute. What happened as a result of the RTE was that everybody now has to be given a place in a normal school. Once that happened, my lord, and as early as 7th of February 2011, this cadre was discontinued. This cadre was not a permanent cadre. It was discontinued.
Thereafter, my lord, some of them have been taken back as education volunteers, again on a temporary basis. What do they want? They want, my lord,
Practice of this temporary basis is the abuse.
my lord, I cannot.
This is the exploitation.
My lord, just
You have children in schools, you
Lord, in
complain of school dropouts.
Lord,
Because
your lordship said, my lord, we cannot
treat teachers.
My lord, just kindly
the number of names that you have. Para teachers, bridge course instructors, voluntary resource persons, Shiksha Bandhus, special educators, Shiksha Mitras. What are all these?
My lord, if your lordship,
all these names, these fixed tenures, contractual basis, this is all forms of exploitation.
My lord, these are all things which happened before the RTE Act came in. Now, my lord, this is creating another, my lord, channel by which persons who are not qualified under the RTE are trying to get permanent employment.
How are they not qualified? Why did you allow them to teach for 21 years then if we did not?
My lord, we did not allow them to teach, my lord. They kindly see, my lord. In order to be a permanent teacher under the present regime, you have to have, my lord, TET qualification, you have to have DLED, you have to have all them.
There are a line of judgments which say that these qualifications which are introduced later on do not have application to those who are already in the service.
No, my lord, to the contrary, my lord, your lordship's judgment says. Sorry, just kindly, my lord, kindly.
Not entertaining.
My lord, I want, my lord.
However, we find no good ground and reason to interfere with the
My lord, this is another cadre, my lord, which will come in now, my lord, which will trouble your lordships like, my lord, the other matters.
You allow this. 58 dismissed.
My lord, just 1 minute, my lord. My lord, if your lordship keeps open a question of law, but my lord, every person, my lord, who is a Shiksha Mitra will come and say that the same has to be applied to me.
It has to be applied.
My lord, your lordships have
to
passed
start
the judgment.
Creating
I am not being able
artificial divisions.
I understand. I understand that your
of exploitation.
I have to, my lord, be given 1 minute to make a statement.
You've been given more than a minute. Mr.
No, my lord. I haven't been able to point out that your lordships have said Shiksha Mitras cannot be given employment in the state of UP. Same persons, my lord, same category of persons.
Not a Shiksha Mitra anymore, he's an education volunteer.
No, my lord, he's a Shiksha Mitra having the same, my lord, the same qualification.
Changed his nomenclature, he's become an education volunteer.
But, my lord, what does he want? He wants 60 years, permanent tenure.
Allow him to work till 60. 58. Dismissed.
Just
we are not entertaining.
Just 1 minute.
As we are almost.
Just give me 1 minute. 1 minute.
Would your lordship keep the question of law?
There's no question of law there.
Not with regard to filing of writ petition, your lordship can always treat this matter as a MA decided.
No.
Not just 1 minute. Not just 1 minute.
Several
But two aspects which have not been brought to the lordship. Not only one aspect.
That are sought to be raised by way of this writ petition filed under Article 32 of the Constitution. We find that grounds made out to entertain.
But kindly consider two aspects.
According to this.
But kindly consider only one aspect, which has not been brought to lordship.
You are covered by the interim order in case.
So they have not been, this is not
You
covered
say
by.
that you were both held under the
I am bringing
50% mark.
No, I am bringing something new which has not been brought to lordship.
Sorry.
One of the directions by lordship was to hold fresh selection against the declared vacancies of earlier selection.
No, we never said that.
Not kindly.
This is exactly what is happening. Everyone is reading into our order whatever they find convenient. We never said that the selection will be restricted only to the 2016 vacancies. That suits your convenience. You can imagine it, but it's not there in the order. Sorry,
Direction.
Sorry, Council, we have dismissed your request.
They are not maintaining
Next
their
matter.
Yes. Appearance may be taken in 50 years.
Yes. Guys, just see the list of dates for 2 minutes.
59 and 60.
Yes. I'm in 59. I'm in 60. The father and son. Just note 2 things. The 18,621. Kindly give a copy to my Lord Justice Sharma. Item number 15.
Yes,
I just pointed. Yes, item 15, the complaint is a nullity because your lordships had a declaration on 11/6/19, which is number 10.
Yes.
This 10 was stayed at 14 by a High Court order of 9/4/21. Then during the stay and contrary to the stay, the complaint was lodged in number 15.
Yes.
Now, what is very interesting, the FIR accepts that there is some delay in lodging because we felt we should not lodge it with a High Court stay. That, my lord, will see at page 214 and 215 of the file. The FIR says at 215 that we should not have lodged. This is the foundation. Number 15 is the foundation. At 215, they say, I'm sorry, this is the original FIR, so the print is small. So they acknowledge that the High Court order of stay is a fetter.
Where do you find it?
214 and 215.
Yes.
Point number 8. Reasons for the middle of the page,
Yes.
reasons for delay in reporting by the complainant due to delay in pendency of the matter before High Court. It is still pending on that day. Filed by so and so. Matter of declaring the account as fraud, etc. The accused challenge. This is not relevant. It's the same order, 9421. Now note one more thing. The 9th of April order at page number 14. Just use the list of dates. It's faster and easier for your lordship. Culminated in a final High Court order of Delhi High Court at number 21, which quashed it. 21 quashed it.
Yes.
And therefore, and one more thing, at page 116, it's the same master circular which I challenged in my writ. So it's not something else. The lordship is not talking of chalk and cheese. And the same master circular at 116 is the subject matter of the complaint at 127. So 116 is my writ, where I got the stay, and 127 is the same master circular.
No, but sir, in the case of Rajesh Agrawal, it was held that even if your status as a fraud account is set aside, the criminal proceedings can continue.
Correct.
Yes.
But there was no criminal proceeding.
Bank can lodge it later also.
Not with us.
Says that only.
No, I'm not a Rajesh. This is not the Rajesh Agrawal point. My lord is right.
What?
Under a High Court order.
Forget about the High Court. The order of this court in case of Rajesh Agrawal.
Yes.
There was subsequent order also clarifying Rajesh Agrawal.
Well, may I just say, the 9421 order